Greetings and welcome back. When I left you last time, remember I had started deciding a case. I talked about the Muhammad Ali case, which was at the time called Clay versus the United States. Remember that case came up through the federal court system, which is where most cases come from. The case had been decided in U.S. District Court and by the U.S. Court of Appeals and had reached the U.S. Supreme Court. Initially, remember the Chief Justice Warren Burger wasn't interested in the case. He did not believe that Ali, then Cassius Clay, had the threefold criteria to be a conscientious objector. And so he did not put that case on the discussion list. And remember, it was William Brennan who said that he really wanted to hear the case. He thought that they needed to hear the case as a court. And so Burger put the case on the discussion list. And they voted 4-4 to hear the case. Remember the rule of 4, that if at least 4 justices want to hear a case or controversy, it's accepted for Supreme Court review. So the case was accepted for review. The attorneys for each side filed briefs. There were some amicus briefs filed. Remember, those are briefs filed by interested parties. And that is where I ended last time. Now, the next stage of the process is for oral arguments to take place. And this is kind of a surprising area for a lot of students. In the vast majority, almost every case, we have a 30-minute standard. And by that, what I mean is each side is only given 30 minutes to summarize their case. And that includes questions from the justices. So, for example, there was a Supreme Court case many years ago where Thurgood Marshall was the attorney in that case. And the Supreme Court justices asked him 109 questions in 30 minutes. You can imagine being asked 109 questions in 30 minutes. Essentially, Thurgood Marshall was able to briefly answer the questions, in many cases with yes or no answers, and got very little of his case summarized. He did win the case, so it worked out pretty well for him. The 30-minute standard is a standard that the justices have placed on themselves. They certainly can waive that standard, and a good example of this, and in fact, this is the last time that this happened, was a few years back when the U.S. Supreme Court was being asked to decide whether or not Obamacare was legal or constitutional or not. The Supreme Court in that particular case gave both sides 3 hours to summarize their case in oral argument. So even though your notes say that typically each side is given 30 minutes, that certainly is true. It is true in 99.99% of cases, but occasionally there is a case where the Supreme Court will waive that, where they want to hear additional arguments. And there is a huge question as to how important the oral arguments are. For example, in most cases, it's argued that most, if not all, of the justices have actually already made up their mind before the oral arguments. But occasionally, I think it's true that the oral arguments are very important. And I will talk about one of these cases when we get to civil rights. It is the most famous affirmative action case in American history, a case called UC Regents versus Bakke. This was a case decided by the Supreme Court in 1978. And in that particular case, there is no question in my mind that going into the oral arguments, the justices were highly split 4-4. And so that meant that the oral arguments were really important for one justice. And I will come back to this notion when I talk about the Bakke case later on. Now, after the oral arguments, we go from the most public part of the process to the most private part of the process, and that is the Judicial Conference. So now, at this stage, everyone disappears. So up until this point, there have been other people involved. The law clerks, for example, were involved in selecting the cases. The lawyers were involved in arguing the cases. The clerk of the court had scheduled the arguments. You'd had interest groups, in most cases, filing briefs on behalf of one of the parties. But now, in the Judicial Conference, there are only the 9 justices. Now, remember, in the Ollie case, it's only 8 justices because Thurgood Marshall had excused himself in this case. And in this case, the Chief Justice speaks first. The justices speak in order of seniority, with the newest justice, who's called the junior justice, speaking last. They then hold a non-binding vote, non-binding. That means that justices can, and in rare occasions have, changed their mind. It doesn't happen very often. Quoting Professor Murphy, the eminent judicial scholar who was at Ohio State for many years, I cited him earlier to you. It was his guesstimation that Supreme Court justices, probably in a typical year, you have a justice change their mind perhaps 5% of the time. I've seen other scholars say that it may be as high as 10%. But what that means is, if the Supreme Court, let's say in a typical year, writes full opinions in 80 cases a year, that means that a Supreme Court justice changes their mind 4 to 8 times in a full year. It does not happen very often. Now, what the justices are trying to do in the Judicial Conference are 2 things. One, they are trying to render a decision. And the decision is simply who won and by what margin. It's basically a scoreboard. So assuming that all 9 justices vote, as your notes point out, there are 5 potential outcomes: 9-0, 8-1, 7-2, 6-3, and 5-4. Now, in recent years, there have been 2 major tendencies. The first I find the most interesting, and that is that the most popular Supreme Court decision has been 9-0. So even though I have stressed how political the court is, how there is a huge split between the liberals and the conservatives on the court, in a typical year, about half of all Supreme Court decisions are 9-0, which means that all of the justices view the law in the same way, that the law is basically settled, and whether you are liberal, whether you are moderate, whether you are conservative, everyone is on the same page. So the most popular decision has been 9-0. Now, to be fair, the second most popular opinion or decision of the court has been 5-4 in about 30% of cases. The court has been highly split, 5-4, again, typically split between conservatives on one side and liberals on the other. So that means that in recent years there haven't been a lot of 8-1, 7-2, or 6-3 decisions. That in about 80% of Supreme Court cases, the court has either been unanimous or deeply split. Now, in the Ollie case, something happens in the decision that I've never seen before or since, and that's why I use this case, besides the fact that it's the only person who's ever gone to the Supreme Court that I've ever met in person. But in the Ollie case at the Judicial Conference, when the justices took their initial vote, the vote was 5-3 for the U.S. government. 5-3 for the U.S. government. And of course, what's interesting is by the time the case goes public, some 6 weeks later, the decision was 8-0 for Muhammad Ali. 8-0 for Ollie. So this is unbelievable. 5 justices changed their vote in a month and a half. And so there must be a heck of a story associated with this. And in this case, there is. Now, one of the things that is intriguing, if you look under opinions of the court, your notes say this is the legal reasoning or why the decision is taking place. It's the legal reasoning for the decision. And underlined, it says that if the Chief Justice is in the majority, he controls the opinion of the court, which means he can write it himself or he can assign it to someone else. So in the Ollie case, the Chief Justice, Warren Burger, was on the winning side. And so he gave the honor of writing the opinion to Justice Harlan. He did this for a couple of reasons. One, Justice Harlan had some background in issues regarding religion in the Constitution. But the primary reason was that Justice Harlan, who was a friend of Chief Justice Burger's, was dying of cancer. And in this particular case, the Chief Justice wanted to give him the honor of writing one last great opinion. Now, what's intriguing in this case is that Justice Harlan asked one of his law clerks to write a rough draft. Here's why I think Ollie should win. He gave him some citations. He gave him the basic argument to use as a template. And his law clerk instead wrote an opinion on why Ollie should win, largely using Harlan's earlier reasoning. And to make a long story short, Harlan, reading the opinion of his law clerk, came to the conclusion that, yep, Ollie should win in this case. So he went to the Chief Justice and he said, I can't write the opinion in this case. And Burger said, well, yes, you are. I've assigned it to you. And Harlan said, no, I can't write the opinion because I'm voting with Ollie, which made the decision 4-4. And if it had ended there, if the court had been divided 4-4, the decision of the lower court, which was the U.S. Court of Appeals, would have stood and Ollie would have lost. To make a long story short, another justice, Potter Stewart in this case, had a lengthy conversation in lunch with Justice Harlan and came to the conclusion that, yeah, Ollie should win. And eventually they reconvened. They had a discussion, and to make a very long and very, very interesting story short, in the end, the decision ended up being 8-0 for Muhammad Ali. And Harlan ended up writing the unanimous opinion in this case. But ironically, instead of writing an opinion on why the U.S. government should win, which was what originally was supposed to happen in this case, instead what happened was Justice Harlan wrote an opinion on why Muhammad Ali, or at the time Cassius Clay, should win. And so this is the only Supreme Court case that I'm aware of where you get 5 justices in one case changing their mind. Remember, according to Professor Murphy, that you usually only have 3, 4, 5 justices change their mind in all of the cases in a whole year, and yet this happened in one particular case. So it's to me, it's a very intriguing case. When I get into the next lecture, I'm going to talk about the various opinions of the court, and if I have time, I will, perhaps, we'll see, finish up the Supreme Court by talking about the concept of judicial review. So I hope that you're tracking these lectures. If not, send me an email so that I can answer some questions online. Take care. Bye-bye.